Officer LaRue.
My name is Chris LaRue, Certified Code Enforcement Officer for Charlotte County. 1854 Little Gasparillo Island is Zone BBI, Bridgeless Barrier Island. This case was initiated on October 28, 2016, after Code Enforcement received an affidavit from Jack Boyer, the owner, were in violation of the Charlotte County Code 3-8-42, subsection D, connection to available private potable water distribution system. I would like to offer Jack Boyer for any additional testimony.
My name is Jack Boyer, Vice President of Little Gasparillo Water Utility, being duly sworn in, and states the following. I own and operate a potable water system that is properly permitted by all applicable federal, state, and local agencies. The potable water system is in regulation, compliance, and provides potable water for human consumption through pipes and other conveyances. The potable water system has at least 15 service connections or regularly services at least 25 individuals daily, at least 60 days out of the year. The potable water system is investor-owned potable water utility company. Regularly, the structure is located at 8154 Grand. Little Gasparillo is capable of being connected, and plumbing has adequate permitting capabilities to supply potable water to the structure. A water line exists in the existing right-of-way and the property line of the structure. In March of 2016, I notified the property owner that Central Water Service is available. As of today, the property owner of the structure has failed to obtain an exemption from the connection required and has failed to connect to Little Gasparillo Water Utilities potable water system.
Good morning.
Good morning, sir. And you are?
Robert Warnick, the owner of the home and the trustee. I'm the owner of 8154 Little Gasparillo Island. I bought the house in December of 2012. At that time, there was no potable water system when I purchased the home, but the house did have a 2,500-gallon rainwater collection water cistern distribution system within the home. The house is used by family members only. The house is not offered for rent. The house is occupied about 4 times per year for about a week, each stay during family vacations. In the spring of 2013, I invested approximately $4,000 to install an additional 2,500-gallon water collection cistern, a 6-step filter progressive water filtration system, and a UV treatment unit for establishing potable water. My potable water is tested annually. Every test is returned that the potable water of the system yields water as pure as bottled water. Prior to the letter from LGI Water, dated and received after the deadline to file for a water system exemption, I had not received any information at all from Charlotte County or LGI Water.
When did you submit that?
The letter was received on March 3rd. The exemption filing requirements for the county was January 1st? February 1st. So I received a letter stating I hadn't received an exemption after the expiration and the deadline of the exemption period. By the nature of this lack of communication by design or omission, the deadline was missed. Changing my system from a proven established water system that yields safe drinking water for my family would require me to find compelling information that the proposed water system was permitted, installed, and maintained in such a manner that abandoning my current water system is the right choice for my family. So I began a due diligence process after receiving the letter. I discovered that LGI water distribution system had not been physically inspected by the permitting authority, the DEP. Further, I contacted the Florida Public Service Commission and obtained public records and revealed that there were a number of violations committed by LGI Water, to include having connected over 100 homes to the system prior to a permit being issued and without the use of a licensed plumber, and a failure to issue water quality warnings to consumers after at least 2 water breaks. That's all public information. I believe I think I have enough copies for you. There was a fine paid for these violations of approximately $6,000. Additionally, LGI Water has laid lines in violation of their permit by not securing appropriate easements with property owners for water line distribution, and after this date and the results will face potential litigation. Requiring me to connect to the water system that has violations and places undue risk to my family's safe drinking water and our pursuit of life, liberty, property, feels like it's an overreach and an infringement. A number of water system improvements that were mandated by the Florida Public Service Commission and the DEP are in process and have not been completed by the water company. I learned last week that that they have filed a second extension to be able to comply with those requirements, and the due date for those enhancements to the water system are actually December 15th, 2016. It feels as though, and having talked to a number of people on the island, that the cards have already been dealt, and anyone who did not immediately comply with the demands, the deck was loaded here. I mean, there's no way to comply when you receive a letter after the due date for the exemption. I invest over $4,000 for a water system that creates safe drinking water for my family that's tested annually. I'm being asked to attach to a water system that has come into play after I established the water system and not having an opportunity to file for the 5-year exemption from the water system. The connection fee to this water system is $4,923. So now I'm being asked to, spend upwards of $10,000 to establish safe drinking water for my family, which I already have.
So the first notice you received was in March?
March 3rd, I have that letter, 2016.
Mr. Boyer, do you have any pending orders by the Public Service Commission or the Department of Environmental Protection against you that are adverse to your utility company?
No, ma'am. In the 30 years we've been operating, we've never had a compliance order. We've met all requirements. What he's referring to is one time a bacteriological notice had not been sent, and by law we have to notify. On the Public Service Commission, we're in the phase 2 of a construction process where we're building a building, and due with SBA funding and things of this nature, we've had to extend that. Application has been made to the Public Service Commission to extend that, but we're in total compliance with everything.
And has the respondent ever contacted you to try to obtain an exception from the connection requirements?
I apologize. I don't understand the question. Has who contacted?
Mr. Wernick, has he ever tried to contact you to find out any information about how to
Yes, ma'am.
become exempt?
Communicated one time. We played I just want to be we just want to provide a service that we're obligated to do inside that certificated area.
Ms. Patel, would you answer a question for me on 3-8-42D as in David? When he gets a notice in March and the deadline was 2 months earlier, how does he reconcile that?
Well, if the county had received an application after the fact, it would have processed it as well, if there had been any demonstration that the notice had been received after the deadline.
So it's not a fixed date that if somebody gets a late notice or something and submits the application, it would have been considered?
Correct.
Anything further, sir?
If I can respond to two
Please.
things. One is I have a letter here dated. So the letter was received on March 3rd. I did author a letter dated April 20th to Jack Boyer going through the fact that I had received his notice and that, I was surprised that I had not been notified by the county of any requirements to connect, and the fact that the letter was dated after the exemption. And, I'm a letter of the law guy. It says if you didn't file by this date, you are not going to receive an exemption. So I have this communication as well as on August, I did not receive a response to that letter. On August 30th, I went out to the island with my family and discovered that a water line had been laid across our property outside of the utility easement. There is a 6-foot utility easement around each plat that's noticed in our documents for the declaration of the property. But this water line was not laid in accordance with the easement. I did send Jack an email, and he did respond back to me. I also filed a complaint with the Florida Public Service Commission. They notified me that easement violations are not in the jurisdiction of the Public Service Commission and that my remedy was through the Charlotte County Court for an easement violation. Jack did call me back on that, and he said that because it was a easement of necessity, that he didn't need to have an easement, which requires me to hire an attorney, and I get all that, and that's kind of part and parcel to this. But in summary, what I'd like to say is that there was no information ever shared that I can miss the deadline for the exemption, so that's new information to me.
Your Honor, the county is willing to continue this case and review the matter further to determine whether an exemption would be possible for the respondent.
Listen, I approve of that wholeheartedly. So what we're going to do then is we'll continue this, and then the county will be in touch with you, and hopefully we'll get this thing worked out. Okay?
Thank you, sir. I appreciate it.
Also, I'm going through the same process, but my date isn't until February 2nd. I just came today to hopefully nip it in the bud and get it done.
What is your name, sir?
My name is Greg Adams.
Come approach the podium. Since he's here, I guess I'll just call his case next.
I appreciate it. Thank you.
Your Honor, I believe he's not on the agenda today.
Oh, he's not. Okay.
No, sir. Not till February.
Oh, okay. I see. I understand.
My idea was I called in, and when I got the letter, I talked to a Mr. Brown, and he informed me today that there would be cases that I could hear and have a chance to speak on this. I never.
Here's the problem,
okay,
sir, and I'd love to accommodate you, but we have a fixed agenda that I'm required to follow, and you're not on it.
Right.
I mean, you're welcome to stay and listen to the other cases and everything, but I think what you might want to do is see how the other cases go, and then maybe get in touch with the county afterward if you think that's appropriate, okay?
Okay. Just in closing, my case is exactly like Mr. Warnick's. I have a water system that I installed, had installed. My water tests out perfect. I was never given that letter that I had to comply with him until March. I got a letter.
I understand that.
And so it's the same exact thing. It's just that mine is in February.
Oh, you learned something new already about the belated application. So
right.
All right. So what we'll do is I guess we'll hear your case in February 1st if you don't get it resolved before then. Okay. And I don't mean to be rude, and I apologize.
No, I understand.
But I have a strict schedule.
I guess I was given some misinformation by a Mr. Brown with the code enforcement. I guess that I would have a chance to speak on this.